I don't want to see marches and the views expressed on this go ahead. The decision's not for me, but I've made my views very clear. This sort of thing has no place in our society.
So the government is facing a backlash from its own MPs over plans to restrict the use of jury trials. It could be one of the most significant rebellions Keir Starmer has faced yet. It might be the second biggest, actually, and concerns don't just come from MPs, but those within the justice system too. Could the proposals be watered down? We'll find out. And in fact, I think we can speak to the Courts Minister, Sarah Sackman, now. Sarah, morning to you.
Good morning.
Thank you so much for joining us. I just want to talk generally about the issue of the backlog and how you're going to tackle it. That's really the purpose of what you're doing, to change the justice system to reduce the level of backlog. The package of reforms you're putting forward is going to reduce the backlog to around 49,000 cases by 2035. That's down from over 80,000 now. But it was 42,000 in 2016, so we're not even going to get back to where we were in 2016. I just wanted to know, are we going to have to be honest and say the backlog is never going to be eliminated?
Well, you're always going to have some cases that need to come into the system, which the courts will need to process. But the situation that we've got at the moment is intolerable. 80,000 cases in the open caseload. Behind each and every one of those cases, there's a victim waiting for justice, a defendant with their life on hold. The system is at breaking point, and that's why we're bringing forward the package of measures that we're talking about today. Investment in lifting the financial constraint on how much the courts can sit, modernisation, but also the reforms in the bill. At the moment, you've got people waiting until 2030 for trials. That's simply untenable, which is why we've got to fix the system.
But is it simply untenable for 49,000 of those to still exist by 2035? I mean, 80,000 is untenable and disgraceful, but nearly 50,000 is still pretty bad.
Well, I'm ambitious about where I want us to get to, but I'm also candid about the scale of the problem. And I think what you're setting out is really a wake-up call to everybody, including those who are resistant to the plans. If not this plan, then what? And if not now, when? We've got to get this back down to deliver timely justice, swifter justice for victims.
What's the empirical evidence, though? The big controversial plan within all of this, and I realise there are many more things than this, but the thing that's causing you the most grief and will cause you grief in Parliament today is the idea to remove jury trials in certain cases. Where is the empirical evidence that doing that will actually reduce the backlog in a meaningful way?
Well, we know that we've got more cases coming into the system than a creaking system can cope with. We know from Sir Brian Levison's report that trials today are taking twice as long as they did 20 years ago. And so the system has to adapt. The evidence comes from the independent review of criminal courts, but also from international comparators. Places like Canada, like New South Wales, they have adopted similar reforms to what we have with judge-only trials. And we know that that makes the trials move more swiftly. Obviously, you've got to guarantee a fair trial, which is what the measures that we've set out today do. But we do need to get the system moving more swiftly so that we can remove these intolerable delays. The
Institute for Government, though, as an independent think tank, has actually looked at the evidence in this country rather than international comparisons and says restricting juries would save less than 2% of court time. If that is the case, if this saves 2% of court time only, is it worth abandoning a tradition that's been a central part of British justice for hundreds of years?
Well, I welcome the IFG's report, and what they have said in their most recent report is that the Ministry of Justice's figures are to be vindicated, and what our package of measures, which includes a number of measures, the removal of the right to elect for defendants and the institution of a Crown Court bench division, together that will save 20% of time in the Crown Court.
That's a different point, though, Sarah. That's a different point. I understand that you're making a whole range of package, but the thing that concerns some people very deeply is you're getting rid of jury trials in certain circumstances in a way that troubles them. And the IFG is saying that will only save 2% of time. 3,200 lawyers have written to you today, including 22 judges and 300 senior barristers. They all think this won't do any good and is a compromise not worth making. The evidence is that this won't save anything and it will cause trouble to do.
Well, 2% on a rising backlog is significant. That amounts to 5,000 sitting days. And you,
so is it worth the 2%, do you think? I've not heard that argument before. It's actually worth doing this for 2%.
Well, the point is exactly what you just said, which is that this is a package, not a pick and mix. The reforms need to interact with one another. And let's remember where this conversation started. A record and rising backlog standing at 80,000 cases. Victims and their representatives are looking to us to pull every single lever. And that includes measures like like the Crown Court Bench Division, which will enable us to set the threshold of who can access a jury trial to the most appropriate level, so that those who need a jury trial for the most serious cases will get one, and that trial will be timely. I stand by that argument, and the evidence that we have presented supports that.
If this is an important and well thought out plan to change the system of justice, why wasn't it in your manifesto? Why didn't you go to the country 2 years ago, 18 months ago, and say, we know the court system is on its knees. Everyone knew that at that point. It was manifestly obvious. We think we're going to change a fundamental part of British life and constitution, in inverted commas, by removing jury trials in certain cases, and you have a mandate for it. If this is such a well thought out plan, why didn't you mention it 18 months ago?
I want to be absolutely clear with your listeners that jury trials will remain a cornerstone of British justice under these plans. These plans, indeed, are designed to preserve jury trial for those who need it and to ensure that it's timely. What we said in our manifesto is that we would put victims at the centre of our plans. We commissioned an independent review with a massive call for evidence led by Sir Brian Leveson, one of our most distinguished jurists. And that provided the blueprint for how we get out of this mess. And what he says is absolutely right. Opponents of these plans are vocal indeed, but they have presented no alternative. If not this plan, then what? And if we don't act now, then when?
And if someone votes against it who's a Labour Member of Parliament, will they lose the whip? How hard are you going to enforce these plans?
Well, we know that there have been one or two vocal opponents of this, Carl Turner in particular, but we also know that there are
We think there might be 30 MPs who are going to vote against it, and the question is, will they lose the whip for going against what's your considered policy?
Well, I know that there will be some MPs that will vote against this, but I also know, as we saw from a letter yesterday containing the signatures of 40 women MPs from the Parliamentary Labour Party, that there is strong support. Their message was clear. The changes in this bill cannot come soon enough for women and girls in the criminal and justice system. And I am listening to their voices as we go through the lobbies tonight.
But if there's 30 MPs who vote against it, what will happen to them? Or will they be able to do that with impunity or not?
Well, I'm not going to speculate on what actions may or may not be taken. We are a party, we are a broad church, and I welcome debate. Nothing difficult or worth doing was ever easy, and I don't shy away from that debate. And indeed, some of those voices will be helping us to scrutinise and improve the bill as it goes through Parliament. But I'm confident that the fundamentals of the plan are right and that they will garner the support of the vast majority of Labour MPs.
You're announcing, as part of the packages, new legal advisors for rape victims. I don't know how what's the correct sort of moral way of thinking about this, because every case has to be judged on its merits for justice to be served. But we know that the prosecution rates, successful prosecution rates for rape and sexual assault in this country are very, very, very low. People even talk about it being effectively decriminalised. Do you have a target? I mean, is it possible to say we want to get sort of 20% of cases successfully prosecuted? How do you try and measure success in this area?
Well, I'm really proud of the announcement we're making today, a new service for independent legal advisors for victims of rape. For far too long, as you say, conviction rates have been appallingly low. And victims tell me, victims like Morwenna Lohman, who I was speaking to yesterday, that they felt entirely failed by the system, that they felt like the ones put on trial. That ends with these new proposals and also the extension of Operation Soteria to our courtrooms. When we talk about halving violence against women and girls, the role that our court reforms have to play in that is vital. Okay. So it's not about having a specific target, but it is about sending a message that we are serious about enforcing criminal law in serious sexual violence and rape cases. And what we are doing today is about centering the victims, as well as bringing down the delays that they face.
Your government's also introducing an official definition of anti-Muslim hostility as part of your community cohesion plan. Why should one organised religion be given protection that's not available to others?
Well, I think we need to start by reflecting on why we are bringing forward this definition, and that is the rising levels of anti-Muslim hate that's being experienced by British Muslim people in this country. That's why a definition is needed to describe and name the types of hostility and intimidation that individuals face as they try to go about their daily lives, a sort of hostility that we will not tolerate. And a definition is useful in that regard because it helps to name that and enforce against it. In the same way that definitions of anti-Semitism have enabled us to tackle anti-Jewish racism in institutions and in daily life, we think that this definition can serve a really important role in tackling hate and improving community cohesion.
There's something happening this weekend in connection with the war in Iran. The Al-Quds march is happening. It's a pro-Iranian regime march that's been described in the past, happens every year, as an anti-Israel jamboree. In 2024, when you were a parliamentary candidate and Labour was in opposition, you said there is real fear in our community about the hate on display around the Al-Quds Day marches. The Home Secretary has the power to ban the marches, and I hope that he will take whatever actions are necessary. That was in 2024. The situation has obviously got far worse given the conflict in Iran. Are you calling for a ban now that you're in government?
Well, I'm clear that hate on marches like the Al-Quds March has no place in British society, and the authorities and the police should take the enforcement action needed against these marches.
Should it be banned?
It's why the Home Secretary has taken additional powers to ban and restrict marches where they're having a cumulative effect on communities, including the Jewish community, but other communities as well. And particularly in the current context where we are seeing the indiscriminate actions of a malign regime of the IRGC, both causing danger abroad and at home, then I expect that our law enforcement authorities will take robust actions with those who express support for those malign
But should it be banned? That's not. And if the actions within the march break the law, that should be prosecuted. I understand that argument. 2 years ago, you wanted it to be banned outright. You're now in government. Should it be banned now?
Well, I think these sorts of marches have no place in our society. It's for the Home Secretary and the police working together to take that decision.
But you demanded, you called upon a Tory Home Secretary to ban it 2 years ago. It's now a Labour Home Secretary. We're now in conflict with Iran. The pressure coming out of this march is actually greater. Do you believe this march should be banned?
I don't want to see marches and the views expressed on this go ahead. The decision's not for me, but I've made my views very clear. This sort of thing has no place in our society.
Sarah Sackman, good to speak to you. Thank you for taking the time. That is Sarah Sackman there, Labour's Courts Minister.